On behalf of Cooley, I hope that you enjoy the following session.
Aloha and welcome to the 2020 Rocky Mountain IP Institute. Enjoy it.
Kilpatrick Townsend hopes you enjoy this session of IP 2020.
On behalf of King & Spalding, we hope you enjoyed this session.
Merchant and Gould thanks you for watching this session.
Hi, I'm Elizabeth Mano from Perkins Coie. On behalf of Perkins Coie, I want to welcome you all to the 2020 IP Institute.
Hi, I'm Michael Chernoff. Murgatroyd welcomes you to the 2020 IP Institute.
Welcome everyone to the 2020 Rocky Mountain Intellectual Property and Tech Law Institute and this, our virtual IP Institute Plus. In the next hour, we're going to hear more about the conflation of licensing law and franchise law. At what point do we as practitioners need to spot in a client's business a license that really comes close to being classified as a franchise? Remember what happens if you're classified as a franchise. You have a host of reporting and compliance obligations, a host of restrictions on your business. So the last thing we want to happen is our license to be reclassified as a franchise, because then we have a world of hurt, as they like to say. Molly, in terms of this world of hurt, who's going to sort of guide us through the thicket and keep us on the straight and narrow?
You know, Nate, it's actually the perfect set of people from Drum Law to guide us through that world of hurt. Mike Drum, the founder of Drum Law, and Alyssa Deach, who is the head of Drum Law's business law group. She focuses her practice on a variety of corporate and franchise issues. And I think that this should be an amazing discussion.
And we should also note and recognize Mike as one of our planning group, member for the last 3 years, who's really done a lot to plan and organize our trademark and copyright topics. So we thank him for that service, and we invite everybody watching throughout the world to enjoy the next hour. Thank you.
Welcome to the Rocky Mountain Intellectual Property Institute Plus 2020. We are so excited that you're joining this pre-recorded video. So I'd like to start by doing some ground rules. Please hold all questions till the end because this is pre-recorded. We're not going to get them anyways. Turn off all cell phones. It's rude. We're giving our time. Please be respectful. Just kidding. We have a wonderful presentation today. It's called the Accidental Franchise. And just so you have an idea of what you're in for, you may have heard that introduction that David Goosewell was going to be presenting with Alyssa Deach. Well, don't want to scare you, but guess what? The role of David Goosewell is going to be played by Mike Drum. So you guys actually got the upgrade today. And it's always fun to see us in animated form. So I am happy to present this wonderful topic, the accidental franchise, and present it with my colleague, Alyssa Deach. Say hi, Alyssa.
Thank you for all the applause, and it's great to see you.
And standing ovations make us awkward and feel weird, so please don't. We know you appreciate this, and we're just glad that you're here. And the abs, you can tell they were pre-COVID. Actually not. But as I tell people, if you're going to get yourself drawn in cartoon form, you might as well make it your best self. So now that you've seen us in our underwear, we're going to proceed. Okay, who we are. Why are we here? What are these franchise attorneys? Well, we are franchise attorneys, and we even have a fridge with awards to prove it. So feel free to go and look at this wonderful fridge. It's in mom format, just like when I was a kid. Put all of our A's on the fridge, but we are franchise lawyers. Drum Law's a franchise law firm. This is what we do. So I don't know how to put this, but we're kind of a big deal. Not really, but we're here to help you today, and we're going to talk about franchise. But if you've been to Rocky Mountain Intellectual Property before, you may remember I'm actually the beer attorney, and Alyssa is as well. So it wouldn't be a beer attorney presentation without a beer or alcohol of your choice. So I recommend you do the same at home. Cheers.
Cheers.
And feel free to join us at the end of the month. I'm actually going to be at Odyssey Beer Works, and we're going to do the virtual beer tour. So exciting an event for the Rocky Mountain IPI Plus. Okay. We are here to scare you. Think of this as sex ed in the 90s. You're a fifth grader. That is our job. We are not doing franchise law 101. There is a lot of dangerous things you can do as a corporate or intellectual property lawyer with distribution, dealership, license agreement. So that is the entire 50 minutes if you come away scared and you know something about 3 different elements, we have done our job. And there are a lot of great franchise attorneys and resources. If you want to become a franchise lawyer, this is not that course. This is designed to help you understand some of the pitfalls that you may run into when you are doing license agreements or other agreements involving the licensing of intellectual property. So we are here to scare you. And Alyssa, let's scare them some more. What happens if their agreements are a franchise? What happens?
It's pretty terrible. So I'm going to go through it pretty broadly, but the laws govern pre-sale disclosures, state registration. So if you are a franchise and you haven't followed all the laws, you could be subject, and your client could be subject to criminal action. Your client could be subject to rescission, which is like a really nasty time machine where you have to go back and get rid of the contract you've already set up, which is expensive and has all kinds of problems. And the big one at the end, if you are the lawyer and you have failed to identify it, that is a malpractice issue, and that doesn't feel good either.
Alyssa, you know what they say about malpractice. You can't have malpractice without practice. Okay.
Wow, I'm still loving that one. Thank you.
Now, everyone knows what a franchise is. It's a restaurant. It's McDonald's, right? We know what franchises are. Everyone on this webinar knows this, right?
Well, so let me tell you, any business that you can imagine has and can be made into a franchise. So we have here some of my favorites, duty calls, which is dog poop removal, and any of you people who have kids, the lice ladies. And just as background, the reason I wanted to point out all these different franchises is I didn't want you to be lulled into thinking you're working with a business that's not a restaurant and that it's not a franchise. So it could be any business.
This is the time of the pre-recorded presentation that I'd like to do an audience poll. Okay. Everyone in the audience, if you receive that blue Valpak envelope in the mail that's full of wonderful coupons and discounts, please raise your hand. Okay, for those at home, about 500 people. Ready to be mind blown? That's a franchise, actually. So franchisees actually buy that. They go ahead and solicit and put those coupons. So in your mail, you are participating in a franchise transaction. Pretty amazing, right, Alyssa?
That's amazing.
Now, we get these are cool, but restaurants still are franchises, right?
That's right. Well, I'm going to tell you about the 2 different kinds of franchises. So the first one that you see here is the business format franchise. And this is the one that most people are used to. You know, you have your McDonald's, the licensor gives the licensee the right to use basically a business in a box. The licensor tells you how to operate the business, gives you training, and then receives revenue in exchange.
Okay, excellent. And I put this slide together, and I intentionally picked this old Taco Bell. I was a trademark attorney before franchise. I love the trade dress. And I love that all the abandoned old Taco Bell stores and have now gotten new life. They may be your local Mexican restaurant. And I live in Arvada, Colorado. One of my favorite old Taco Bell that's been newly converted is $1.35 a scoop. I mean, I love that comfortable feel of look at the Taco Bell arches. You can see the drive-through that they no longer use. And $1.35 a scoop, my friends. I mean, that's a pretty good deal. Alyssa, do you have any favorite like Taco Bell buildings that have been converted?
Nothing, but the $1.35 a scoop really speaks to me. So thank you.
You know what they say about Taco Bell and shots, right? You never wake up the next day and say, that was a good idea.
Thank you. Thank you, Mike. Okay, second type of franchise is actually generates more revenue than the first type, but you don't think of it very often. So this is the product distribution franchise. This tends to be the distribution of soft drinks, you know, car dealerships, gas stations, and you have a distributor, a dealer, a distributor, and you're distributing just one product. So a Toyota dealership, a gas station. Anything else to add on that one?
No, just big, and it's an interesting area. Like you said, with the, you know, you can't buy brand new Chevys at the Toyota dealership, right? Very product specific. Okay, This is where we're going to delve into about 4 hours of intense history of franchising. We're going to start really early and go up to modern day and a little bit. Just kidding. This is not what this topic's about. But I do like to impress you and give something that you can impress your friends. So, Alyssa, what was the first franchise in America?
This looks like a Singer sewing machine. Is that right, Mike?
It is. Singer Sewing Machine was the first franchise. Take this away, wow your friends. You'll be the hit at all the virtual dinner parties that you're going to. And what year do you think was the first franchise? Can you give us any insight?
You know, that looks like, I'm going to guess sometime in the 1800s.
Impressive. Now, last thing, I'd be amazed if you knew how much the sewing machine was, because I'm guessing it couldn't be cheap, otherwise everyone would have one. How much was the sewing machine in 1800s?
I heard it was around $120.
Wow, amazing. Oh, it's just great. You learn so much. This is awesome.
So much. All right, well, so the first franchise came out in the 1800s, but it was not until 1970 the states actually began regulating franchise. And, of course, it was California who passed the first franchise investment law, and it is California today that is still the thorn in our side. After California, some other states followed, and it wasn't until 1979 that the federal government got involved and began regulating franchises.
So I think it's safe to say that we can blame California for this and everything else that's bad in the world?
We still do, but yes.
Yeah, okay, good.
Yes.
That's fact. Good.
I think that's right. Okay, so this is a particularly boring area of franchise, the legal side, but we're going to give you a little bit of background. Background to know is that there's federal law, which is governed by the FTC, and state law. So the federal law, really just disclosure laws. Once you get to the states, there's 14 states that have what we call them registration states. That's because they have franchise laws that require additional registration and filing. You'll see the states here. And then there's other states that don't have specific pre-sale franchise law, but they do have what's called franchise relationship laws. So keep in mind, if you're wondering if there's a franchise, first you have to consider the federal law, and then you have to consider whether you're in a state that has state franchise law.
Listen, what's the greatest state in the country to live in?
Colorado.
And it's obviously a great state to live in, not for the skiing, weather, mountains, but because we're not a registration state, right?
Which is awesome. What does that mean,
Okay.
Mike?
It means that you're going to be governed by the FTC and the federal law, but you don't have any state-specific laws that directly address the franchise relationship. So we're a very friendly place for franchisors to start. That's why we have a lot of franchise companies here, because the laws are generally more favorable to franchisors when it's not a registration state or the bad or the dark side. Okay, though, Lisa, I think we can save everyone about 40 minutes because I got an idea. I'm going to do a license agreement, and I'm just going to, section 1. This is not a franchise. This is a license. And guess what? I'm going to put initials. Both parties are going to initial it. So it's a license agreement because we said so, and time to move on. I mean, that's a contract, a legal binding contract. Why do we have to waste people's time now?
Well, first of all, let me just mention one thing. A franchise is a special kind of license agreement. And so let me just throw that out there. But Mike, it's very sad, and I do want to let you know, you may have a franchise, and I throw around the F word easily, even if you haven't called it a franchise.
You went there, didn't you? Okay. Both parties agreed that we really, really, really don't want it to be a franchise. Okay, we signed off, so it's got to be. But you tell me it's not. Okay. I guess, oops, I franchised again. I played with your heart and gave you a bad license agreement. Thank you. That's my Britney Spears impression, everyone. But, right, the elements of franchise under federal regulation and state laws are relatively general, ambiguous. This is make great law school exam questions. As a consequence, some of these arrangements between licensor, licensee, manufacturer, dealer, distributor can inadvertently be our accidental franchise. So think Britney Spears. You don't want to oops and do it again. Okay. We are living in interesting times. Normally, this is going to be a live presentation, and we've all had sacrifices because of this. Here's the biggest tragedy, though. If this presentation were live, this is where I'd bring in an expert, and of course it's going to be The Simpsons. And The Simpsons have everything, and they have a wonderful clip on franchising, margins of buying a pretzel franchise. But because we're on this virtual platform, I didn't want to tech it up with the Simpson clip and not have it in sync. So instead of Homer telling you about franchise law, you're going to have to hear from Alyssa and Mike. We'll do our best, but recognize the tragedy. It's here. Alyssa, this is something I'm sure our audience won't get sick of, and they're not going to probably even remember this, right? What's the theme? What's our presentation really about?
All right. We are going to give you 3 themes, and here's what it is. Under federal law and under most state law, if you meet these 3 elements, you are a franchise regardless of what you call it, regardless of how you've documented it. Here it is. Money, control and assistance, and trademark. That's it.
All right. Well, to quote one of my favorite movies, Idiocracy, I like money. So let's chat about item 1, money. Now, yeah, I get it, right? Okay, as long as it doesn't say initial franchise fee, royalty, I get it. Those are franchise words, right? Can you tell me about this money element, this wonderful number 1? Can you give me a little more backstory on this? Thank you.
It is actually a very low threshold to meet. Within the first 6 months, there has to be, it's around $500, although it increases over time. If there's a payment of around $500, you have met that threshold. So sometimes it can be in direct franchise fees, which could be called a license fee, a royalty, but then there's indirect franchise fees, and that could be counted towards this $500 threshold too. It could be rent paid to the licensor as a landlord, advertising assistance fees, training fees, and those sneak in on you.
And here's a great example. To pull this case, Mitsubishi, basically they had a distributor, they terminated the distributor, and their argument on the element is they didn't meet the money element. They didn't have that license fee, that initial franchise fee. They didn't have that royalty. What the court found, though, was the licensee or franchisee's payment of $1,600 over an 8-year period, so $200 a year if you're averaging, for manuals, service manuals, actually satisfied that element of a fee. And look at the lesson here. The accidental franchisee was awarded a $1.525 million jury verdict because of this accidental franchise and termination of the accidental franchise that was sold as a distributor. Okay, Alyssa, I would love to do this next slide, but I tried to buy an inflatable pool for my kids. It's summer. They can't really go to all the public pools. And my HOA denied the request. And I already ordered the pool. But the worst part for the kids was the pool had to get delivered, and then we had to then take it back. So they got to see the present being delivered and then it being taken away. So this one's too close to home. I can't do this slide. Would you please talk about it?
Let me bring it away. Okay, this is an example of another fee that didn't look like a franchise fee, but was considered a franchise fee in order to meet this threshold and have this relationship be considered a franchise. This fee was the licensor set up a co-op advertising account and had the licensee paid into it. And this co-op advertising account paid for advertising. It didn't go directly to the franchisor. And even that was sufficient to be considered an indirect franchise fee and meet the threshold of this element. So it really is a very low threshold.
Okay, so just a quick refresh. How many elements are there to franchise?
I hear someone calling it out. There are 3, and we're talking about the first one.
Okay, we did
money.
Okay, I think we're good.
That's right.
Number 2, okay?
All right.
Control assistance, and let's give the audience time to read this funny. This relationship isn't working. You're too much of a control freak. Why do you say that? Because you make me. Now say it again. Okay, control and assistance. That's our second prong of 3, in addition to money.
Okay. So this is an area where it's still a pretty low threshold, but it's more of a gray area and you can play around with it. So when we talk about significant assistance, we are really talking about assistance regarding the method of operation. So is the licensor giving training programs, providing accounting systems, giving marketing advice, providing an operations manual, any of those or those together, that's enough to meet the significant assistance piece. What about control, Mike?
Okay, so to trigger that second element of control, you're looking for controlling things outside of potentially like the intellectual property. You're controlling specific hours of operation. You must be open 24 hours. You must be open 9 to 5. Production techniques. You must use the system to make the product. Accounting practices. You must use QuickBooks Online. You must give me access. Here's personnel. You must wear this uniform. It's kind of governing more just that business operation. Training programs. We're going to give you an intensive training program. We're going to control your methods, procedures, and kind of give you that operations manual.
Okay.
If you don't mind taking away.
Okay. So as you could anticipate, people are always trying to think, well, how do I get around the significant control or assistant piece? And the FTC has determined that there are other ways where if you're just doing this, this is not considered control or assistance. The biggest one is if you have trademark controls, which are designed solely to protect the trademark owner's goodwill, that alone is not significant control or assistance. Some other key types of control or assistance that also alone are not control or assistance: inspecting goods or services, approving advertising, providing just promotional materials. But you can see these are pretty limited, and if you are granting someone the right to use your trademark and start a business, this is pretty limited.
Excellent. And remember, we have this federal structure we talked about under the FTC. We have 14 states that add more. Just going to show you, it gets even trickier on a state level. So some of the states, you can actually meet that second prong of assistance or control simply by providing a marketing plan. And even if that marketing plan is optional, it could still count to satisfy that second prong of, am I a franchise? Okay, once again, Alyssa, how many elements do we have, franchising?
We have 3, and we're talking about the second one. We talked about money, this is control and assistance, and I think there's a third.
See, there was a guy in the back. I could tell he was like, how many elements were there? So I just wanted to, he didn't raise his hand, but I could tell, so thank you. Money, assistance, control. Then let's go, I started my career as a trademark lawyer, which is similar to franchising. It's a great gateway. It's a gateway career to franchising. So my favorite element is trademark. If you had a favorite, would it be trademark, or are you more of a control?
Money. It's money.
All about the
Benjamins,
Benjamins,
I like the money
right?
one. That's right.
Okay. So this is what at the IP conference. This is why we're talking about the trademarks. If you're going to license your trademark, you're always going to hit one of the 3 elements of this franchise. Okay. Are you licensing a trademark, trade name, advertising, or other commercial symbol that the recipient can use in its business? And that could be the logo mark, it could be the word mark, it could be an inadvertent use. This one's pretty easy to spot on the top level, right? If you're going to be I need you to be McDonald's, I'm McDonald's, you're going to be McDonald's, great. That's easy to see. That probably has some franchise elements. You're going to operate a business under my same name. Here's where it gets a little tricky. Like I said, name of business, that's kind of obvious, but you can satisfy the trademark element in other ways. So let's go ahead, and I'm going to make Mike's hamburgers, and you can be Alyssa's hamburgers, and the audience can be audience hamburgers. It's great. But guess what? Everyone's selling that Big Mac. And you can sell other things, but I'm going to make you sell the Big Mac. That's going to be the attraction and drive you in. Well, that trademarked product actually may get you in that franchise third element. And as a baby attorney, I dealt with this. We tried to get a dealership program, and we really tried to get away from the trademark element because we wanted the money and we needed some control and assistance. And we got away with it in a lot of states, but there are some states where we had to really be careful about that branded product, even if it was vaguely in the background. And man, you do a lot of research when you think your legal career is on the line, but the point of this slide is it can sneak up on you, right? Even if a franchisee identifies its business by another name, if it uses an indicator that's affiliated with a network or it sells a trademark good, you may inadvertently meet that element. And, the slide here about Sloan Implements, You can see it's definitely not John Deere implement, but look at the branding, right? Their main sign is the John Deere tractor, green, yellow, and you see the beautiful tractors out there. So is it substantially associated with that trademark? So back to scaring you, most people will get the name of the business, but if there's any type of trademark that's being shared, utilized, even in the marketing material, you could trigger this third element. And Alyssa, I'm going to have you scare them a little more, because I feel like I've been the bad guy and you've got to be the good cop here. Take them away, those three elements, because guess what? Time to blow their minds with maybe you don't need all three.
All right, so I'm going to go back to, again, we've been talking about the elements under federal law, but as I mentioned, a substantial number of states also have state franchise laws. And New York, which is also a tough one, you can meet the franchise element under New York law if you have the money element and the control and assistance. And here the marketing plan is the control and assistance. They're using different language for New York. So you don't even need a trademark in New York. And Mike, one other piece I thought I'd throw in, because I think this is very sneaky. There are certain arrangements, and I'll talk about one of them later, where it's not described in the agreement as an express trademark license. And the FTC has found in certain cases that even if you haven't in writing expressly said this is a trademark license, if you have some sort of business arrangement and you haven't prohibited the use of a trademark, that was enough to meet this element. So this also is a very low threshold to meet.
This is pretty scary, right? Man, I wish
so scary.
It'd be nice if we can give the audience some trigger words like, hey, red flags, these are things you should think about because these may become that accidental franchise. Alyssa, are there such words that everyone should be aware of?
I'm going to tell you, these are the words that, this is a key one. You want to look for these words, and if you see anything like this, you need to start thinking about whether this is a franchise. Dealership, excuse me, distributors, certified, resellers, excuse me, I know this is nice for everybody.
I'm going to take it away. So we're going to go license agreements, and these are things like, wow, it's okay, I'm a dealer, I'm not a franchise, I'm a reseller. And I'm guessing everyone's wondering, or obviously if you're Alec Baldwin, then you probably are going to be no. So one of my favorite movies, Glenn Ross, and if you haven't watched it, I highly recommend it, or at a minimum, watch the 7-minute Alec Baldwin speech about ABC's Always Be Closing, or if you watch the Alec Baldwin SNL where it's Christmas time and he's giving the speech to the elves and talking about Always Be Cobbling. But we see this a lot with independent contractor, broker agreements, sales agreements. So, hey, you're not a franchise. You're a commission broker, but I'm going to give you a commission, i.e. you're not going to get the full 100% of the sale. You're going to have to give me 70% fee. I'm going to control your operations. I'm going to make sure that you go back and make sure you do 9 to 5 and obviously you're selling my trademark product. So if you run into Alec Baldwin, it may be an accidental franchise. That's the point of this slide. And then, Alyssa, you run the awesome corporate department of drum law, right? And you're an amazing corporate attorney.
Right.
In addition to franchise attorney, I think there's another one that you should be careful of, or the audience needs to pay attention to.
I felt like this one deserved its own slide. I think this is one of the sneakiest ways that a franchise can come in. And as a corporate lawyer, I think I can see you corporate lawyers out there. This is something that I really want you to know. So let me tell you how this comes into the franchise world. You have a business owner, he starts a restaurant, it's really successful, and he decides he wants to have more locations. So he, finds other locations, but he needs more money, so he brings in other locations. So now you have Restaurant 1, who's owned by the original owner, Restaurant 2, Restaurant 3, who have investors. So that is actually often a franchise, and I wanted to get into how and why it is. So most corporate attorneys really follow through on the first step of this, which is setting up the company, bringing in the investors, thinking through securities laws. But the second piece of that is that the only reason that location 2 and location 3 can use the restaurant name and the menu and the recipes is that they have a license from Restaurant 1. And so even though there's common owners, because it's not 100% owned by the same owners, the same entities, you have a potential franchise. And so that's something I want you to always think about, because that doesn't even have license in the name. It's just an implied license.
Excellent. So you get the phone call, hey, I don't want to be a franchise. F word, it's bad. No F word, no F word. Is it worth your time trying to avoid these three elements? Alyssa, thoughts here. Tell me what you want, what you really, really want.
Well, so we often have people come in and they're all worked up. They don't want to be a franchise, or they're not a franchise. And I always like to take that first step and at least think through whether they should avoid being a franchise. So, most people want to avoid being a franchise. It can be expensive. You're putting together these big disclosure documents. It is time consuming. It also can take a while from when you set it up to you actually make a sale. Those are the downsides, but I also like my clients to think through, sometimes if it's a structure that really is a franchise and they're trying to get around it, it can be just as expensive and time consuming to get around it, and it's also risky. The other piece I like to think through is that putting your intellectual property, putting your business into the form of a franchise is a really good way to protect the intellectual property. And the other cool part is that you now have a brand that you're having other people help invest in to grow, and it's not your money, it's theirs. So I like to at least think through that first step.
And my favorite, I get this call all the time. Hey, Mike, I have a new idea. I got my business. It's similar to McDonald's, but I want to do a license agreement. Well, it's like, okay, it's similar to McDonald's, or it's similar to this franchise competitor. What, besides me changing the name from franchise to license or distributor or dealer, how is this not a franchise? And of course, you get, well, it's not a franchise because I said it's licensed. No. Go through they got, how many elements were there again, Alyssa?
There were three, and I see someone jumping up in the back, but yes, three.
Here, we got come afterwards. We got treats for anyone who answers questions, so we got one for you saved. There's three. What are those three again?
Money, control and assistance, and trademark.
And let's see, this is probably 95% of my I don't want to be a franchise phone call. There's usually barely any nonprofits, so they always want a money element, some type of fee, and there's always usually a trademark element, right? Because, hey, the point of me licensing this is to grow this brand, or you're going to take the brand that I built and make it better, or use my brand equity. So what we see, like I said, 90% plus time is, of course, we're going to get rid of control and assistance. And I ask my clients, why would you want to give away control or assistance for your brand, for your intellectual property? And I would tell my clients, you're going to not answer the phone if you license your intellectual property to someone and they have a question, or what they're doing wrong, you don't want to assist them. So it's back to, sometimes you have to question, why are you avoiding a franchise? Why are you avoiding the F word? And, we have those three wonderful elements. And for all the trademark practitioners here, about this wonderful naked license agreement. If you have to have control in any trademark license agreement, or you could risk having a naked license agreement that would abandon your mark. You have to control the nature and quality of the goods or services. Like, for instance, if I were to license the Drum Law name, I need to make sure that you're most excellent, wear cool T-shirts, and have a suit coat when you get presentations. If you don't live up to my brand, the Drum Law brand means nothing, and I'll lose the wonderful rights to this trademark. So you already, by having a trademark license agreement, you're hitting at least 1.75 or 2 of the 3 elements. And that's why, this is why we're here to scare you, right? Because you have 2 in every agreement. You're going to have at least 2 partial ingredients to a franchise.
All right. So if we are talking through the details of how to get around the control, let's talk about what might be acceptable control just in detail and what might be unacceptable control. Unacceptable control being that you've met that threshold and you could be a franchise.
All right, I want to be good cop for once, if you don't mind. Let me be the good one. I'm going to make you do the bad. So this is I love analogies, examples. Hey, I have a McDonald's, but I don't want to be a franchise. I want to do a license agreement. Okay. Here's the example. Think Mickey Mouse, okay? this is how a license agreement works. You can license the right to make Mickey Mouse t-shirts. I can control the colors of Mickey Mouse, the size and the proportions. I can control, you must print Mickey Mouse on organic cotton because Mickey Mouse is top class and it needs to be a comfortable t-shirt. And I don't even know the difference between dye inks and pigment inks, but for this illustration, I'm going to say you must use dye inks. So I'm controlling that this Mickey Mouse product that I'm letting you make is going to meet all of these wonderful items so that it still is at goodwill and association of Mickey Mouse. Bad cop, you're up.
All right, so bad control, which would lead you to meet that threshold of having significant control or assistance, things like setting the hours. You can sell my Mickey Mouse shirt, but you have to be open from 9 to 9. Things like site selection. You have to sell your Mickey Mouse shirts in, a walking mall, and it needs to be in 900 square feet. Another key one is you can sell my Mickey Mouse shirt, but you can't sell any other products. So any of those or those together would go to show significant control and assistance, and you've met that threshold and could be a franchise.
So you're saying prohibiting me from selling Bugs Bunny t-shirts does not protect the goodwill of the Mickey Mouse shirt? Because it has nothing to do with the quality of that shirt that you're printing? That makes sense. Okay, I think I'm learning something here.
But look, keep in mind these franchise guys are a little odd, but that's their rules.
And I just realized how dated our examples are. I'm going to have to eventually hit my kids up to a little more modern Mickey Mouse Bugs Bunny example, but that will be for next year's presentation, hopefully in person. All right, this is take a snapshot, right? We're trying to teach and scare, but this is maybe teach a little more. So let's give some tips, Alyssa. You're a corporate contract lawyer. Let's see if we can give the audience at least some tips if you're going to try to keep doing these license agreements that may risk. Go ahead.
All right. So I know we have said that it doesn't matter what the parties say, but it still can't hurt to put in your agreement the parties intend that this not be a franchise, both parties agree with it. So if you're going to try and get around it, we still put that in there anyhow.
Okay, so not dispositive, but I also like, hey, maybe when I said this license agreement, that licensee thought I was getting control assistance, thought I was going to be a franchise, and maybe by calling it out right away, we may see this problem before they sign on the dotted line and cause more issues. So, like, hey, this is not a franchise. And it's just kind of fun sometimes to add this is not a franchise agreement in the agreement. I kind of enjoy that, even the negative. And then this is a good one. State clearly the scope and use of that licensor's trademark. As we discussed earlier with the John Deere tractor, with the Big Mac, and even if you are, so we're selling you Mike's Hamburgers, and you have a Big Mac available from the McDonald's, but guess what? I don't want Mike's Hamburgers to be a franchise. So I may say that you are expressly prohibited from calling that 2-meat, Thousand Island dressing, secret sauce, 3-bun patty burger a Big Mac. It actually may be a default of the license agreement if you use any of the licensor's marks. If that was how many elements were there again for franchise? 3. Okay, if you were trying to get rid of that trademark element, make it clear. Like, make it a default. Hey, you can't use this trademark. We've agreed, 1, not a franchise agreement. 2, you better not use my trademarks because I will have to terminate this license agreement of my business system and non-franchise agreements.
Okay, and you're seeing a theme here where if we don't want to be considered a franchise, we're going through those 3 and disclaiming 1 of the 3 or 2 of the 3. So here's another one, and this goes to the money element. If it is royalty-free, be very clear about that. Another one is look into have an attorney help you out with this. You are attorneys. Have a franchise attorney help you out with this one. Which one are the registration states? And those are ones that you may want to completely steer clear of.
North Dakota, South Dakota, Rhode Island, California, Hawaii, Michigan, Illinois, Indiana, Virginia, Maryland, South Dakota, North Dakota. Boom. And I didn't even name all 14, but when you say them really fast, it impresses clients because they think you really know them all. But yeah, that's another trick. I don't know, if you want to become a franchise lawyer, say all the states or at least like 10 of them really fast. Practical tip. Okay, moving on. State clearly the day-to-day business operations are the licensee responsibility. Remember, you get to make Mickey Mouse, use organic cotton, you are responsible for setting your own hours of operation, your personnel, your employees, what other products you may decide to carry, what state specifically. Don't be vague here. And I'll go in this one, Alyssa. This is back to another. This is back to another indirect franchise fee. Be careful about any inventory or supply requirements. If you're selling 10 of those delicious hamburgers a day at Mike's Burgers, and that's pretty much every franchisee or licensee will sell 10, you can't make them buy 100 at a time or 1,000 at a time. That may be an indirect franchise fee because you're forcing them to carry an excessive inventory, and therefore you're getting a larger payment up front.
Okay, and that gets to the money element. And this is another one. This goes to the control and assistance. The only controls that you're talking about that should be in your license agreements are those directly related to products and services under the trademark and whether they're meeting trademark quality assurance standards. So very, very limited.
Okay, and we got a question there. Alyssa, the question is, how many elements were there for the franchise? Front row. Thank you. I appreciate the participation. How many elements are there?
Okay, this is going to be a tough one. I'm going to do it in the other order, but trademark, control and assistance, and money.
Wow, 3, 2, 1. Impressive. Okay, good news. I have a law firm. I'm going to not franchise because it's a bad word. I don't like the F word, okay? I'm going to hire you. You seem pretty competent. You gave a CLE. You have a nice Zoom background. So you're going to help me. We're going to get rid of one of these elements, okay? We're getting rid of one. I'm in the clear, right? We're good. This is it. Give me my license agreements. I'm killing one of them. We'll decide which one later, except for probably not the trademark because it's my name. But you got me in the clear, right? Killed that element. Killed one of the. We only have two.
Right.
We only have two.
I have some really sad news for you, Mike. Even if you have cleared the franchise element under federal law, under state law, you are not in the clear. There are still some related issues that you need to consider.
Shut the front door, Alyssa. Shut the front door.
No, it's true. It has a really cute name. They're called the BizOp statutes or the business opportunity statutes, and half of the states have these kind of laws. The FTC also requires disclosures in business opportunity offerings, and one thing to keep in mind is that if you are a franchise in most states, you're exempt from worrying about business opportunity laws. So now what are business opportunity laws, Mike?
Okay, so remember, we're scaring you. 3 elements, license agreements. Okay, we're going to fight the 3 elements, but we still may have trouble. Business opportunities. This is a lot of you see the flyers on the street. Work from home, make $10,000, or any comment on any internet post, that work from home, make $10,000. Those usually qualify as the BizOp. And what a BizOp generally is, a seller directly or indirectly will provide you with a good or service to the buyer. These goods or services enable you to start a business. The seller makes one or more representations about this business to the buyer, and the buyer pays some sort of consideration in exchange for these goods and services. This is not a BizOp topic, presentation CLE. This is an area even some franchisors struggle with because if you are a franchise, you're exempt. You may have to do some filings, but you're exempt from these BizOps. If you're not a franchise, not only do you have to comply with that federal BizOp disclosure, which is a 4-page disclosure document, you then have to have a separate agreement for each of those 26 states that govern BizOps. So it actually is easier and sometimes more cost-effective to actually be a franchise. And this kind of brings me to another point I like to make to my clients. Everyone thinks franchise is McDonald's. You must, so much control. A franchise can be as much or as little as you want. You can, as long as you disclose it. That's the beauty of it. It's, the franchise disclosure document. You disclose that we won't help you. We'll only help you on Fridays from 2 to 3 p.m. You are in control as the franchisor as how much or how little that you want to do. And I think a lot of people forget that, and they try to avoid this F word that they think is a bad thing, but it can be whatever you want. And then my favorite too is, well, listen, the licensee doesn't care. It's not a franchise. He doesn't want a franchise disclosure document. Of course not, because following the franchise laws, if you hit the 3 elements, protects the licensor or the franchisor. If you don't follow these elements, you basically are getting a get out of jail free card or ACE card to that licensee that when they change their mind, they may get that rescission, try to undo the transaction, give me money. So I like that. Well, he's okay with it. He doesn't care. Yeah, of course not. It protects the licensor. So keep that in mind. It doesn't have to be McDonald's. It doesn't have to be everything. You can make it as little control assistance, as little money, or as a few trademarks as you want. But Alyssa, here's the thing. I'm going to franchise Drum Law. I don't want to franchise Drum Law. I want to license it. And I've seen 5 other law firms yesterday even that they're licenses. So why can't I be a license? Everyone else is doing it. Okay? It's not fair.
I get this a lot. I think this is the equivalent of, looking for your physical symptoms and going to the doctor with what's wrong with you. I probably get a call once a day about a client saying, oh, everybody I know is doing this, why can't I? So we thought we'd throw in here, which is something we talk to the clients about. When would this get up? Let's say we set you up as a license. When would you get caught that you were actually a franchise? And here's the areas where it comes in. When you try and, as the licensor, when you try and terminate your licensee, you decide not to renew it, there's any territory issues, who belongs to this territory, and this is my favorite, a lot of times competitors are calling state regulators and saying, I know this guy should be a franchise but isn't. And it's catty, but we see it a lot.
So one of my favorite client stories, and we'll keep the names out to protect the innocent or guilty in this case. We had a client that we were going to launch a franchise system, but we were in early stages. And one of their direct competitors was actually doing a license program, and they had 3 elements. And when my client called the state of California to report and tell on them, California actually said, oh, by the way, we looked at your website, and we noticed some things that you're talking about franchising, and you're not registered and you don't have it, so they got in trouble. So I thought that was kind of interesting on the karma elements. If you're going to call, make sure that you have clean hands before you tell on someone else. But, we get this a lot. If your Drum Law license agreement that actually has all 3 elements but makes the millions of dollars that I guaranteed you, no one cares. You're not going to tell on me. You're just going to be happy with the millions of dollars that you're making, and you're going to be grateful for my inadvertent accidental franchise. So as long as everyone is making money and happy, you may get away with it. The problem is, just like many contracts, if things go south, that's where you get in trouble. And there's these they who should not be named, the franchisee lawyers, and they will, believe me, they're out there. And I like to, if I'm in a pessimistic mood, I tell my clients, and if there's kids listening, mute, don't get off speaker. Easter Bunny, Santa Claus, and the franchisee that failed because they're just bad at business. These things don't exist. These are mythical creatures, and it's amazing. Anytime that licensee goes out of business or that franchisee fails, it's never their fault, and it's time to sue your franchisor, or hey, let's find someone because it wasn't my fault. So there's a lot of bad lawyers out there. Just kidding. I have good franchisee lawyers, friends, but they're out there, and if your franchise licensee talks to them, you may have an issue there. There may be something that you have to deal with. Then, Alyssa, this is kind of a tangential, but this was a recent hot topic in the franchise space. Okay, so fine, you got me 3 elements. I got money, control assistance, franchise. I'm going to be a franchise. I'm in the clear, right? And guess what? I'm going to control the heck out of these guys. You know why? You didn't want my license. You want me to control you. I'm going to control you so hard. Any other issues I should be concerned about?
I'm going to let you talk about this one, Mike, but the other thing to consider is, do you have a franchisee or do you have an employee? And there's a few factors you can consider. Mike, take it away.
So, hey, trademark license, got to have some control, but not too much control because you're a franchise. Well, now we're going to just mess with your heads. Oh, yeah, but if you're a franchise, don't have too much control because then you can be deemed an employee. And what happened is the janitorial franchises got really hit. I mean, basically, you bought the franchise. They already had national contracts. You would go and clean these big buildings, and you would give the franchise or 40%. So are you exerting too much control? And then McDonald's also got hit with this. They controlled how many employees. They basically ran your business for you. So it's a delicate balance of you need enough control to protect your brand standards, to protect your intellectual property, but you need to let that franchisee, you can't tell them how many employees to have, or you need to fire this employee because then you're overstepping it and you may have joint employer issues. So have some control, not too much control, or somewhere in the middle, and that's another fun complication, and hopefully we're still scaring you. And then this is always, I actually use an actual email, and I love this, so I always like to show this. I mean, this was actually received. Hey, Mike, I had a conversation with someone recently that owns a restaurant concept in Texas. He explained that he stopped opening his own now and does a license agreement instead of franchising for other operators using his branding. He has done this with 4 locations, and they are high traffic locations. Thinking that this may be an option for me, right? Back to our slide. Just because someone else is doing it doesn't mean that you can. And you may not even know what they're doing, right, Alyssa? Like, hey, I see my competitor doing it, but
That is correct.
is there any exemptions from franchise law? If I meet all 3
All right.
elements, can I still be exempt? Do I have to have all these wonderful things?
There are exemptions, and there's something called exemption-based franchising, and it's kind of it's not what you want to do. It ends up, like I said, if you're trying to be a license or you're trying to be meet an exemption, it's risky. It takes a lot of time and money. But let me go through just really quickly the exemptions that are there. So first of all, keep in mind that first you have to make sure you've met the federal exemptions. And if you're in Colorado or another non-registration state, you're done. But after you meet the federal exemptions in a state like California, you also have to make sure you've met the state exemptions, and they're not always the same. So you have the minimum payment exemption is really just kind of an offshoot of not charging the $500 in the first 6 months. You have a fractional franchise.
These are my favorites. I love the
Sure,
fractional.
go, please.
I call it like the Starbucks in the grocery store, as I tell the clients, right? It's going to be a business located within another business. And because it's already you're selling to a business, and if the revenue of this fractional or smaller business is less than 20% of the entire business's revenue, you may be exempt under federal law and some state laws, but you may not. But that's when we get a lot. It's that business in a business. And then I'm going to skip over, and let's go to the more common ones. Let's go with the sophisticated investor exemption and kind of the corporate. What's the corporate equivalent, corporate and securities equivalent to that one? To the sophisticated.
The
investor.
accredited investor.
The only issue here, though, for under federal law, it's $5.8 million. So it's a very high standard to meet. And then another good one: if you're willing to have this franchise agreement be a handshake, you may be exempt under federal law. So don't necessarily think I would advise my clients of that, but that is something that you may do. If that's kind of what you want to do, and if you're a handshake type person. But in COVID, I don't think so. Maybe this is, instead of a handshake agreement, it'll be an elbow bump agreement.
Well, and just if you look at these are pretty limited, and so if that's what you're hoping to do, there's not a whole lot of options there.
And then, yeah, right, even if you made these federal exemptions, they're not always available at all the state levels, are they?
Right.
Okay, we're running out of time, which is great because we gave 50 beautiful minutes and we met our CLE minimum requirements, but I had a question in the back I have to ask. Someone said there was a cool word that franchise or attorneys got to use until 2008, and that changed. Can you shed any light on this, Alyssa? It was the guy. It was a person in the back. You can see it right there. Yeah. Okay, thank you. Great question, by the way.
All right. All right. So this gets a little technical, but we kind of mentioned this before. There's a disclosure document that you bring. You have to prepare, and in the registration states, you have to register. It used to be called the UFOC, which is very catchy, and now it's called the FDD.
Yes. So it doesn't sound like a swear word anymore. So and by the way, if you see franchise lawyers that are willing to draft a UFOC or UFOC, probably would stay away. Those are expired 12 years ago. So you want those FDD lawyers.
That's right.
Unfortunately,
That's right.
This is all the time we have, but Alyssa and I, we love what we do. We're franchisors. We get to wear cool T-shirts. We work with fun people, and we love to give back to the community any way we can. So if any of you guys have questions, feel free to email us. You can go to drumlaw.com to 2Ms and see us and see our fun advertising and fun slides. And here I'll leave our email addresses up. But we're glad to help. If you just want to run a quick thing by us on a license agreement, we've done a lot of these, and we'd be glad to kind of assist any way we can. So we're here as a resource. Thank you so much. Everyone stay safe, and we really appreciate it.
Thank you for joining us.